Good morning, everybody. It is a pleasure to welcome all of you to this grand finale of the MLI course, which was conceived and organized by the WRC of IFA India. And over the last 3 days and today morning, I'm sure you would have all learned a lot about the MLI and what are the nuances about how it has to be given the due respect while interpreting treaties going forward. And I will now request Kush to introduce the speakers.
Thank you, sir. To not take too much time from the session, as I'm sure everyone knows who all the three panelists are very well, just a brief introduction. So we have Pramod Kumar, sir, who is the former Vice President of the ITAT, and he's authored more than 15,000 judgments and on very complex and contentious issues. And I think everyone who is working in international tax and transfer pricing has read multiple judgments authored by him. And he's also served as the board of director on the board of directors of the International Association of Tax Judges in the past. So we welcome Pramod sir for this session. We also have Ajay Vohra sir, who is a senior advocate practicing at the ITAT High Court and Supreme Court level, and he has argued several cases involving complex issues which have wide ramifications. And he was designated as a senior advocate in 2014, and he has been rated as one of the most highly acclaimed legal experts in the Asia Pacific region by Asia Law Leading Lawyers Guide for each of the years of 2006 to 2014, prior to his designation as senior advocate. And he has previously been the chairman of IFA India branch. So thank you, sir, for being here. And we have Mukesh Butani, sir, who is the managing partner at BMR Legal, a boutique law firm, which has been given an incredible recognition as a top tier one firm in tax and transaction services, global growth firm by World Economic Forum and Harvard Business School. It has featured in a Harvard Business School case study called BMR Advisors, Competing on Quality. And Mukesh sir has also been a past chairman of IFA India branch and is a member of IFA's Global Supervisory Board and a reserve panel member of the SIAC. So thank you, Mukesh sir, for being here. I'll just share my screen with the presentation, so you can let me know when to change slides.
Yes.
Possible?
Good morning, everyone, and thank you. If I may start, I must first make a very honest confession that this MLI workshop that is being organized by IFA, which is supposed to be concluding with this workshop on brain trust session, the organizers and the researchers sent us a very complex set of case studies for us. Frankly, when three of us looked into this, we forget that this is way beyond our intellect and way beyond our knowledge and experience that we have. And we were actually thinking, what should we do for this generous 1.5 hours that has been granted to us? So we came across a very interesting case study, a real life case study. And as you would imagine, that having a celebrated judicial member in Mr. Pramod Kumar on the panel and having a celebrated lawyer in Ajay, we felt that the best way we recognize ourselves is with cases, and we should discuss a case. I'm going to just introduce this case. It's a very interesting case, and actually, it's the first case that has hit, judicial forum of the level of the Federal Court of Australia, which deals with some of the nuances. The case has not interestingly gone into the merits of the dispute. The merits of the dispute, many of you who are practicing in India will be able to relate to very, very easily. This is on the characterization of royalty income. So we have decided that we are going to spend the next hour plus that we have with us, and please feel free to drop in the question in the question box. We will take it as and when it comes. We felt that we will first introduce the case. We will discuss some of the practical challenges that are arising out of this case, particularly with regard to the principle of certainty, which I thought after reading Action Point 14 and after reading MLI and after reading the mandatory arbitration clause, which doesn't apply to India technically, but in the case that we are going to talk about, which is Australia-Ireland Treaty, there is a mandatory arbitration clause. And then we also wanted to hypothesize that once this case gets into the merits, either by the courts in Australia or through the MAP process in the treaty, what kind of questions will arise from a public international law perspective. So this case is one about really what has happened, which is what we are going to talk about in the first. And second, if we get into the merits of this case, what is likely to occur. So this is a case where Oracle Australia was making cross-border payments to its subsidiary in Ireland. These were payments that were made for software royalty, and everyone is familiar with the software royalty concept. And the ATO in Australia picked out this controversy and questioned the characterization of this royalty. And it came to the conclusion that tax should be withheld in Australia on such payments. In the meantime, the ATO released two draft versions of tax rulings. And this version gave further explanation to characterization of royalty, particularly on the vexed issue where royalties paid for a software or an intellectual property right. All the ingredients that we deal with royalty characterization, were present in this draft ruling that were given. These rulings, as it is, became controversial, particularly with the United States and the ATO and the US Treasury, which kind of became a bit of an area of discussion even at the OECD negotiation table, because the US Treasury had different view than what these rulings guided us. These rulings clearly suggested a very, very strict interpretation of the term royalty, particularly on the right to use principle, which is identical to what we face in India. And this particular ruling obviously became a subject matter of dispute with 15 large multinationals, predominantly US multinationals, and as a result of which Australia had to take a decision how to be able to deal with this issue. The case that we are going to talk about is Oracle Corporation Australia. Oracle Corporation in Australia, next slide please, chose to adopt what typically taxpayers do in India, which is pursue the remedy in the domestic courts and also pursue the MAP process. But here the MAP was not between Australia and United States, because the payment were being made by Oracle Australia to Oracle Ireland. The concerned treaty was Australia-Ireland Treaty. Now, Australia-Ireland Treaty is a covered tax agreement, which means both Australia and Ireland are signatories to the MLI, and hence the provisions of the MLI apply. And the case, the Australian court was dealing with this case in the context of that. Specifically, it included a sub-license fee that was paid for the years 2013 to 2018. The fees were paid as representing a bundle of rights that Australia obtained from Oracle Ireland for use in the computer program. I mean, I don't see any difference between this case and the case that the Indian Supreme Court dealt with in engineering analysis, because this also case involved the question of withholding tax on royalty. The amounts here are not relevant, but for whatever it is worth, it involved a fairly material sum of money. 253 Australian dollars was involved at the center of the issue. Next slide, please. The commissioner issued notices to Oracle Ireland, and Oracle Ireland was asked a file request for MAP under DTAA. Penalty notices were also issued. Oracle Australia filed before the federal court just to make sure that it doesn't lose out on its domestic remedies. The federal court granted a temporary stay, insofar as the MAP proceedings are concerned, and this became a controversial issue from an MLI perspective. The ATO, Australian Tax Authorities, suspended the MAP and asked the court to proceed with the lawsuit. So the controversy surrounded on two issues. One,
प्रतीक आज नहीं है.
yeah, Nilesh bhai, if you can keep it
क्या
on mute.
प्रतीक आज
Your-
मैंने ग्रुप में मैसेज डाला हुआ है कि एक कोटेशन है, मतलब एक कोटेशन में डिस्प्यूट चल रहा है वैल्यू में, तो आई वांटेड टू टेल देम कि भाई भिवंडी से अपने को भी लूज फर्नीचर उस प्रोजेक्ट के
Can we mute Nilesh bhai?
कोटेशन के वैल्यू पे.
Perfect. Thank you, Nilesh bhai. So the controversy surrounded on two issues. One, the Australian Tax Authority's decision to suspend the MAP under Article 9(2) of the MLI and asking the court to proceed with the lawsuit. And second was the stay that was granted by the Federal Court of Australia to permit MAP procedures to progress to finality. Some of the observations that were made by the court are interesting, which we wanted to just explain in the subsequent slides. Go ahead, please. Interestingly, the judge, while denying the claim from domestic proceedings, quoted that ordinarily the stay should be granted, the stay from domestic proceedings until the resolution of MAP should be granted. But there were overwhelming reasons, and the overwhelming reasons he quotes it as the public interest for finality in determination of the characterization of royalty. Remember that there were about 15 odd cases that were there. And what was public interest involved over here? The public interest involved over here was there were 15 other multinationals embroiled in the controversy. The approach by the tax authorities in Australia had already, as a result of the administrative guidance, private ruling, and the friction with the US treaty, created very strong concerns. And there was a clear disagreement between the tax authorities in India and the Treasury, which is a policy-making arm of United States. And hence, it is an opportune, the Oracle case is an opportune case for Australia to give a final word or final opinion in the country, in Australia. So that was really the underlying, philosophy of the judge that guided the judge to say that MAP proceedings be stayed and the trial be started. The trial has not started, so we are not discussing the merits of the case insofar as Australia is concerned. Next slide, please. I felt that this is an opportune time to discuss some of the other interests that arise, and which is what we are going to discuss in the panel. Number one is that because Australia and Ireland are signatories to a mandatory arbitration, how does the court proceedings in Australia now cause friction with what the arbitral tribunal could have done? And because now the arbitral tribunal through the MAP process is prevented from deciding this case, will Australia be viewed as, or will the domestic laws of Australia be viewed as circumventing the mandatory arbitration process in the interest of public policy? So interestingly, the court used the public policy argument to get over the MAP process, which has mandatory arbitration, but there are many things that arise. There are many, edits that have already been written by Australian tax experts. Some of them who are supporting the domestic trial process believe that courts in Australia have more expertise, all the wherewithal to decide an issue of this nuanced issue of this nature, because it concerns the Australian copyright law. And how can an arbitral tribunal sitting wherever it is be more competent to be able to address this issue? This is the first aspect. But does that become a good enough reason for Australia to circumvent the mandatory arbitration process is still a central question. The arbitration process, we are going to look at Article 16.1 and Article 16.2 of the MLI as well to read what is there. And we are also going to look at the equivalent of Article 16.1 that India has adopted as a part of the MLI process, which when we were preparing, Mr. Pramod Kumar pointed out how it is different. The other aspect is that the arbitration process really takes a lot of time. There are significant delays. It results in potentially pushing the resolution to many, many years back. And because there is public interest involved, it should be decided on an expeditious manner. The court did not ignore Article 26, the MAP process between Australia and Netherlands, but the court acknowledged instead that there is Article 26. The Article 26 contains a mechanism to resolve the dispute. In fact, it went ahead and further said that statistical evidence on implementation of Article 26 suggests that there have been discussions where disputes have been resolved to avoid double taxation. However, at the end, the court weighed all the considerations and concluded that in the broader public interest, a judicial determination by the Australian courts is very critical. The question that arises, a knee-jerk reaction by all international taxpayers, all multinationals, is this the end of the MAP journey? Is this how the MLI process going to work? Is this how the revised MAP process under Action Point 14 going to work? Because the Action Point 14 improvement of the MAP process wanted to strengthen what was a terribly frustrating MAP experience for multinationals. Those are some of the questions that arise. I'm going to put out the last slide after this because this brings the issue to fore insofar as India is concerned. For those of you who follow the MAP process would recall that India went through a peer review process. It had feedback in the peer review process, and in pursuance to that feedback, the Indian CBDT issued notifications by way of MAP guidance. One important part of the MAP guidance that has attracted an attention and which has come up under some criticism, certainly I, for one, personally have a disagreement with this CBDT circular, and I'll explain the reason why I don't agree with the CBDT circular. But this CBDT circular, which is binding on the tax administration, simply says that MAP access would be denied in instances where an income tax appellate tribunal passes an order. And the reason given is that the competent authorities in India cannot deviate from the orders of the tribunal, which is the last fact-finding authority. And if a situation of this kind occurs, the competent authority in India will request the competent authority of the treaty partner to provide a correlative relief. Now, that, in my view, is too naive and too nice to accept. It's like Indian competent authority telling the foreign competent authority, you know, I've carried out an adjustment, but hold on, I cannot give you the benefit of MAP because I have a CBDT circular that binds me, but hold on, can you give a correlative relief? I don't know which competent authority will do that, but nevertheless, this circular is there and it is staring at us. And if I read the Australian court decision, I am really very worried for multinationals from a tax certainty point of view. So let me pause over here. Before we get on to the other principles, let's get some quick reaction from our panelists. Mr. Pramod Kumar, first over to you. You must be very elated with this circular because for a change, the CBDT is acknowledging that ITAT is super and their decisions are binding on us. And I wonder if this is true, why do they keep on appealing to the High Court against ITAT decisions?
I think rather than reading it as something specific to the ITAT decision, you should see it in this way, that if someone is seeking adjudication of a dispute through the judicial mechanism, then MAP will not be sitting in judgment over that. I think that's the only way you can give it an element of rationality. And that makes sense also, that if you're proceeding with the ITAT and you are also proceeding with the MAP at the same time, it doesn't make, I mean, both the things are parallel things. Coming back to the Australian decision, as I could see from a quick look, first of all, to suggest that the courts give a better adjudication, I think that is something not really in consonance with the scheme of the BAPS when you see the dispute redressal mechanism. Today, we are looking at tax certainty. We are providing how to strengthen the MAP mechanism. And the idea really is that the matters there's a finality to this. Please also bear in mind the fact that insofar as the Australian court is concerned, that was, that matter was before the federal court, which is the highest court there. So what observations which have been made vis-a-vis the superiority of the courts or their ability to adjudicate on the nuances of the issue is something which, to my mind, may not have the universal acceptance, and it would probably be quite contrary to the way things have been visualized in the BAPS reforms. That's my quick take on this part. Now, second thing is, as you pointed out, that this decision deals with the mandatory arbitration part and also on the Article 16 of the MLI, which talks about MAP. So far as the Indian position is concerned, and if you look at the MLI document, India has its reservation, except for the second sentence where a time frame is given. So to what extent these observations would generally apply to the Indian situation is something which is not quite clear to me. However, there are two things which are significant. And these two things are, number one, how to interpret the MLI. And as your team member pointed out to me a short while ago, that there's an interesting document, and that is there is a multilateral document with respect to the interpretation part. And that document talks about how should Vienna Convention be applied. This document is Multilateral Convention to implement tax-related measures to prevent BAPS. And this is opinion of the Conference of Parties. And in this opinion on Conference of Parties, they have given a very interesting analysis. I don't know what's the judicial value of this analysis as to how should the Vienna Convention apply with respect to this interpretational part. And the court also seems to be quite influenced by this when they have, for example, looked at the BAPS Action Plan 14 in interpreting the mechanism, the manner in which the mechanism is to work. Ordinarily, when you look at BAPS Action Plan 14 for the purpose of interpretation of MLI provision, I would think you could have done it only under Article 32, which deals with the supplementary means. And in supplementary means, these come into play either to corroborate the conclusions drawn by the judges, or when they realize that the conclusions drawn by them lead to either an absurdity or some obscure meaning. But this, what is called COP, Opinion on MLI Interpretation, is an amazing, very interesting document, which decides for judges as to what will constitute context, what will constitute supplementary material. And one of the points which has been made there is that they mentioned about the object and purpose and the explanatory, and they have said the explanatory statements form part of the context in terms of the MLI. and thus they have taken into Article 31(1) together. I don't really, to be honest, as someone who has worked in the judicial system at whatever level for long years, I do not understand how can someone drawing an instrument would also decide how should instrument be construed, particularly where Vienna Convention has been given a certain role. And they have even gone to the extent of deciding in Vienna Convention which part will relate to what, which is covered by 31(1), which is covered by 31(2), and to that extent. So when you read that part of the judgment, that's a very interesting part about the importance given to these documents in 31(1) rather than 31, rather than 32. And then you read this judgment in conjunction with this COP opinion, which I'm sure will be an interesting document to anyone who is dealing with MLI, and which tells about how these papers are interpreted. That part seems very, very fascinating. That's my quick take on the decision. And yes, once the matter comes on the merits, then there are interesting nuances to it as to what basis the interpretation should take place, what should be the broad principles. But I think that stage is not there right now. Right now, the only question is whether the court proceeding should be held in abeyance to facilitate map disposal. And in the ITAT, we do it on routine basis. I mean, I must have done on hundreds of occasions when someone comes to the ITAT says, look, my matter is pending before the map. Please hold the proceedings in abeyance. That's a normal thing. But here, the courts declining to do it and rather saying, no, we are superior forum to adjudicate upon this because it has a normative effect and there are many other parties involved, is something relatively offbeat. And the justification for this kind of an approach, finding the justification from the BAPS plan is also very interesting because the way the BAPS document look at the domestic dispute redressal mechanism is not as flattering to the judicial forum as the Honorable Court thought.
Thank you for your comments, Ajay.
Mukesh, I was trying to put this decision of the federal court in perspective, especially in the context of the invocation of MAP by Oracle. So as I see it, MAP was invoked, MAP has been suspended. It's not that the right to continue with the MAP proceedings has been terminated. Second, the time for MAP will automatically get extended post this federal court judgment and post the Australian tax authorities coming out with a ruling on their interpretation of the definition of software in the Australian tax legislation. This court today has given no view on merit, so we'll await what the Australian tax authorities will ultimately come out with their interpretation of what is the meaning to be attributed to the term software. So I see that once you have a view from the Australian tax authorities, the taxpayers would continue with the MAP proceedings, challenging that view on merits. If the Australian competent authority feels bound by the view taken by the Australian tax authority, that would be a subject of negotiation, and assuming that the MAP does not go through. Since the Australian-Ireland Treaty has a mandatory arbitration, I don't think the Australian side can shy away from sitting on the arbitration table. They will necessarily have to submit themselves to arbitration, and the arbitrator's decision on merits, according to me, in terms of the MLI, should supersede what has been unilaterally decided by the Australian tax authorities. Now, if you put this in perspective, I think why Australia is probably insisting on suspending the MAP proceedings and coming out with their own interpretation on their domestic legislation, possibly maybe that there may be some taxpayers who decide not to invoke MAP. There may be some taxpayers who are not coming from Ireland, and the view on the interpretation of the term software as appearing in the domestic legislation may bind some other taxpayers. So when they talk of public interest, they are looking at maybe an authoritative view, an authoritative ruling from the Australian side on their domestic legislation. And some taxpayers may not necessarily invoke the MAP proceedings, may not get into an arbitration stage. So that will be the view insofar as the tax authorities are concerned. So in order that there is uniformity in the views of the tax authorities in Australia, this could be one approach that has been followed to suspend MAP in this particular case. But it is clearly not termination. This taxpayer Oracle will still have the right to pursue this matter all the way up in MAP and ultimately leading to arbitration. That's my take. I think that this is more in the nature of an interim order where your stay has been declined.
But what is the impact of those, the expression, notwithstanding the remedies in the treaties and irrespective of the remedies in the treaties? That's the difference between these two expressions, which have been dealt with by the Australian court.
Australian court said, so basically, if
I
you
was
see,
wondering what is the basic difference? I mean,
no, if you see,
notwithstanding the remedies and irrespective of the
correct.
remedies, what is
So if you see, this is an application for stay of proceedings. It's an interim application.
absolutely.
So if
And
this is an interim
application is also
application,
passed an interim order.
it is an interim order. So it doesn't take away the right. It cannot take away the right. That right is granted to a taxpayer under the treaty. That right can't be taken away by the Australian court unilaterally. That's my take on it.
The way multinationals are viewing this interim order, Ajay, is that right at least stands suspended
Correct.
up until the time the Australian court makes a determination.
True.
I also wanted to add a little further color because I wanted to present the arguments on both the sides. So I'm going to present two slides to explain what is the central issue of controversy, and people will be able to kind of draw a lot of parallels between why Australia is taking the view it is taking, or rather why the Australian courts have taken the view it is taking, which is granting of the interim stay.
Right.
So if you can just move the slide, Kush. The issue at hand is a very old issue. This was an impasse between Australia and United States because Australia issued draft tax rulings, which is obviously binding on the ATO. And it, in pursuance to that ruling, updated the guidance on software and intellectual property. And it specifically dealt with software pre-installed in a hardware. And it said that Australia is expanding its definition to include such payments related to software distribution, where rights in the software copyright are granted, even if those rights do not get extended for reproduction. A classic issue that the Supreme Court dealt with in the engineering analysis case. The Australia believes that the OECD commentary suggests that payments for software distribution that do not involve exploitation of copyrights are business income and not royalties. But just like India, the ATO disagrees, asserting that the additional rights that are granted to the distributors do take the shape of it being royalty. And Australia the Australian Tax Administration justifies this interpretation, saying that the OECD commentary has outlived its importance. And it is citing many reasons, including technological advancements that have taken place in the business, which typically render the traditional distribution models redundant, is really the explanation. The next slide is also an ongoing controversy that Australia has been having with United States, and most of the 15 companies that have been picked up as cases in the interest of public interest are the US companies.
Correct.
The US has clearly been dismissive of the Australian claim, and as a result of which the United States believe that it militates against the guidance that is issued by the Treasury. So, considering this as the fact, I just wanted to, ask Mr. Kumar and Ajay, would this stance taken by the Australian court be seen as having some justification? Or do you think that no matter what the ongoing controversy is, a treaty is a treaty, an MLI is an MLI, and that should be respected more?
Mukesh, I missed the last part of the question. Your comment with respect to that amendment?
No, my comment is that given the ongoing controversy, would the position change under the public international law or treaty law?
I'll be honest, I missed the attention for a while. I lost this. I think Ajay could answer it first. And then I'll come
So,
back.
as I see it, Mukesh, like we have seen in engineering analysis, a unilateral amendment in a domestic legislation cannot override the treaty. So if and you very rightly pointed out that most of the 15 companies that were talked of in public interest in this in this Australian tax court decision are largely US corporations. And I am aware of at least of multiple of them who have adopted the same business model of, granting rights to the Ireland entity. The Ireland entity thereafter distributes the software to jurisdictions across the globe. So that's the business model that is largely followed, which results in almost nil or negligible tax in the country where the software is actually distributed. So in this kind of situation, Australia has, in order to probably get its fair share of revenue from the software distributed in its jurisdiction, decided to amend or decided to interpret its domestic legislation in a manner that leaves the multinational with a liability to payment of tax in that jurisdiction. But having said that, as has been categorically held in engineering analysis, and I think that principle is accepted world over, that a unilateral amendment in your domestic legislation cannot, even if in conflict with the treaty interpretation, cannot override the treaty. So I think ultimately when it comes to merits and when it comes to resolution through MAP or through arbitration, that treaty position will ultimately prevail. That's my conviction and that's my optimism. Second, insofar as MLI is concerned, if this is a covered tax agreement, I don't see how the Australian side can shy away or walk away from what has already been signed. They will be governed by the MLI provisions. They will be governed by the treaty as it stands to the extent modified by the MLI. And ultimately, between the two sovereign states, it will be the treaty position that will ultimately be given credence, and that will ultimately override, supersede the domestic tax interpretation. That's my take on this, Mukesh. Thank you.
I would agree with you, Ajay, and I would also add that when you make a unilateral amendment to the law, which is contrary to what the treaty interpretation would normally take you to, that is a violation of Article 26. Because 26 article, when you look at Article 26 of ECLT, it requires a treaty to be performed in good faith. And at a point of time when the treaty is interpreted or is amenable to interpretation in a particular manner, the government, or that is the contracting state in this case, makes an amendment in its domestic law so as to frustrate that interpretation. That can be anything but performance of a treaty in good faith. That takes you to one more question. And that question is about the static versus ambulatory debate. Now, assuming that an amendment made in the domestic law, and you use Article 3.2 to go to that meaning, then it would also be a fit case where you ignore the ambulatory meaning for the simple reason that ambulatory meaning in that sense, in that situation, or a meaning in accordance with the amended law as it prevails at the point of time when it's implemented, would result in an interpretation which is contrary to Article 26. So if you have to make a choice, if you do the interpretation in static, which leads you to result in consonance with Article 26, or ambulatory, which leads you to result which is contrary to Article 26, I think for this reason alone, the choice will have to be for the static meaning. And if you take the static meaning, then the domestic law situation will not be as relevant from the perspective of 3.2. And that is the view which was taken by one of the judgments I wrote in the case of ACIT versus Reliance Jio, and that was the year 2019. Me and Brother Sood were on the bench. And of course, by then, New Skies were also there. And there was an similar amendment in the royalty definition. So at the end of the day, the amendments in domestic law, to the extent these are made to frustrate a particular interpretation of the treaties, would be in violation of Article 26 and would also be disregarded when you interpret the treaty in that context. That seems to be the possible way of looking at it.
Thank you,
And
sir,
this
for
is-
clarifying. For those of
And
you
the same situation will prevail with respect to the MLI also, whether you have a treaty as a result of MLI or pre-MLI, principle remains the same.
Yeah, I will just come on the application of Vienna Convention on the MLI document. But for those of you who are interested in the principle that Mr. Kumar just articulated, he laid down this principle in the Reliance Geo Infocom decision. It's a 2019 decision of Mumbai Tribunal. Uh, in this decision, the central issue was on characterization of royalty under Article 13.3 of India-Singapore Treaty, wherein Article 3.2, the context was interpreted, and explanation 6 to 917 was interpreted. And in this case, the court, while coming to the conclusion on the expression of the term process, which, if I'm not mistaken, was dealt by the Delhi High Court in Asia Sat case
Asia
as well, and the High Court in the Siemens case as well. It laid down a very important principle. It relied on Article 26 of the Vienna Convention on Law of Treaties and said that the static or ambulatory approach or a unilateral treaty override, howsoever, is really not permitted, whether in a static or an ambulatory approach. Then it went ahead and emphasized that the additional test that is required to be applied while adopting the ambulatory approach is whether the amendment in the domestic law ends up unsettling a conclusion arrived at under the pre-domestic law amendment, which has reversed the judicial rulings in favor of the resident jurisdiction. And it relied on the Vienna Convention on Law of Treaties, wherein the tribunal stresses on the source jurisdiction taxability under the treaty provisions, and the legal amendments will influence the taxability even under the treaty situation by source jurisdictions unilaterally will not be permissible. So that's really the principle that Mr. Kumar was referring to. Sorry, Ajay, I interrupted you. You wanted to add something to it because
No, I said that I think I'm only, kind of appalled by the repeated attempts by the revenue to somehow underdo the treaty position. If you talked of process royalty and you talked of Reliance Geo Infocom, authored by our co-panelist, Mr. Pramod Kumar. In the recent judgment in Telstra, again, the Delhi High Court has come down on the revenue saying that, there is an n number of attempts to somehow trying to push through the same interpretation to be placed on a conflicting definition of a term in the treaty and in the domestic legislation. I think Telstra exhaustively deals with, once again, this issue of royalty, the amendment in the domestic legislation, process royalty versus equipment royalty, and so on and so forth.
correct. There is while we are speaking, I thought it will be useful if we start taking questions as well. There is a question from Mr. Vijay Goel. He's asking specifically, and I think, Ajay, this could be in relation to the remark that you made earlier that this is an interim decision.
Right.
His question is, will Australia allow MAP post their judicial decision? Ajay, Mr. Kumar.
Well, I think what the judgment itself starts is they have suspended the MAP.
Okay.
They have suspended the MAP to allow the Australian tax authorities to come out with their views on the domestic law definition of the term royalties and adjudicate that dispute. It doesn't take away that right. I don't think a court can take away the right for MAP once it has been validly invoked within time.
But equally true, isn't it, that if the court has taken it on itself to give an opinion, and this is an opinion of the federal court, on a issue which is in public interest impacting a batch of taxpayers?
Mukesh, I think the issue before the court is limited to whether there should be a stay. I'm just reading this preamble of the judgment, reasons for judgment. This is paragraph 1. The question on the present application is whether these 3 proceedings should be temporarily stayed pending the conclusion of a mutual agreement procedure under the terms of a double taxation avoidance agreement between Australia and Ireland, I conclude that they should not be. So all that is saying, allow the domestic proceedings to go on. That's all. The judgment has to be read in the context of the dispute that traveled to the court. Nothing more. Nothing more.
Okay. So, so you
But
seem
when
to
you
be
say
suggesting.
interim judgment, I also think that it's an interim judgment in the sense that at the end of the judgment, the judge himself said, suspended this judgment also by granting them leave to go to a division bench. If you look at the
So
last
that's,
sentence,
yeah. So that seems to be the firm view of unanimous view of the panel as well, that this judgment of the, or rather this interim stay of the federal court is not with regard to suspension, or rather it's with regard to temporary suspension of MAP, not with regard to the competent authorities taking a view on the MAP as well.
It may, Mukesh, tomorrow be a different issue that Australia comes out with their conclusive view on the interpretation of the word royalty in their domestic legislation, and the competent authority of Australia refuses to budge when the map is ultimately undertaken with the Irish authorities. That's a different story. And I said that will then necessarily have to get into mandatory arbitration, which is provided in the Australia-Ireland Treaty pursuant to MLI.
and please understand what they have done in the last sentence is about a matter being placed before the full court.
Correct.
As a matter of fact, yeah, this is what they have done. They said
Right.
because of the importance of the matter, let the matter be placed before a full
Right,
bench,
right.
and they have granted liberty for this.
Correct.
So if you really see it in effect and draw some parity with the how things function in India, it is like matter coming up before a division bench and division bench saying, look, for these are the detailed reasons where I think there's something interesting. My prima facie view is this, and let the matter go to a special bench.
Sir, and then I'll just only add to that this is matter coming before the single judge on a question of an interim stay. That's all. Nothing
Absolutely.
more. Nothing more.
And that too, he himself grants stay on his own order.
Stay, correct. Right.
He says,
Leave to appeal. Leave to appeal to the division bench.
So honestly, if it was to happen, I would imagine in ITAT, nobody would have really bothered about this decision as much as we are bothered, because it's a writing on the sand anyway by judge's own admission. And in the end, he says, no, I understand the importance of the matter, and therefore it should go to a larger bench. So where is the question of adjudication on the core issue? That is a matter that will come up now. That's one thing. And second thing, when judge talks about normative effect of the judicial orders, that has been a traditional problem with the MAP orders, because MAP orders, the way they function, the kind of secrecy they function, the kind of, this is not a very transparent process. Even the decisions are not in public domain. And therefore, while a judicial ruling will have the normative effect on all such similar cases, MAP ruling does not have this advantage.
Let's now move ahead.
Mukesh, one question I must ask you is, just because a MAP ruling does not have a normative effect on similar other disputes, should that be relegated to a status lower than a judicial ruling? And remember, that's what the court has said.
My answer, or rather my reaction, is no, it should not. Because to some extent, even discontinuing the MAP process or temporarily suspending the MAP process goes against the grain of the principles of interpretation of treaty. And I will be able to offer some more explanation in the context of Article 31 and Article 32 of the VCLT when we go to the other slides. I also wanted to present a very hypothetical situation over here. Imagine the Australian Federal Court getting into the merits of the case and eventually coming at an outcome which is against the taxpayer. Let's assume that it agrees with the ATU's decision. I personally feel that a prejudice would be caused at that point in time, because I can't imagine a practical situation where the ATO would be able to take a position contrary to what the federal court has taken. because the ATO will now be further fortified. It would come and say, I have already issued rulings. I have held on to this position. I have a face-off with the US Treasury. Now the Australian Federal Court is giving a stamp of approval to my interpretation. What is the basis for me even to stand and negotiate MAP? So in my view, even if the right to MAP remains open, if the Australian court decides the case, there is gross prejudice to the taxpayer. I don't know what Ajay, you and Mr. Kumar feel about it, but this is my view.
No, then it
No,
will necessarily get into arbitration.
absolutely,
Right.
because remember, this is a case where mandatory arbitration is there.
Right. And the two MAP authorities can't come to a consensus. In that situation, they will invoke mandatory arbitration. There is a clear divergence of view between the Irish authorities, assuming they uphold the US Treasury stand, and the Australian tax authorities. And in
That
the
is a
arbitration, I think all these principles that we are talking about, the MLI preparatory work, the VCLT principles, that will weigh on the arbitration panel. Of that, respect needs to be given to these principles while interpreting a tax treaty between two sovereign nations.
And that precisely is the reason why so much of emphasis is led by the OECD on the arbitration. Because everyone understands that in the MAP, there is a certain limitation within which the competent authorities can make concessions. And those limitations, in fact, restrict the efficacy of the mechanism. And that's where the arbitration has a much, much greater role to play. However, the Indian position is against arbitration, and for whatever reasons, that's historically the fact. And that probably...
Mukesh, let me just illustrate this point. We have now the Supreme Court ruling on MFN. Assume we had an arbitration clause, right? The MFN position on the notification, leave aside Nestle's case, on the notification issue, that when should the MFN clause actually be effectuated. Now that is contrary, in our understanding, contrary to what we would normally read on first principles with respect to the provision becoming automatically applicable if the plain language provides so. But we have a different view from the Supreme Court of India. The Indian tax authorities are bound by that view. So even in a MAP proceeding, they will continue to uphold that view and say that we can't budge, we can't concede, we can't give up. Now, if that were to get into arbitration, then a question will arise, whether their view, which is in our respectful submission, in conflict with what is the treaty understanding between the treaty partners. I think that would have been a question that the arbitrators could have decided.
Absolutely. No doubt about that.
Yeah. Let's try and now move some slides, because I wanted to discuss some Indian cases and the principles articulated under Indian cases. If you can just go back to the VCLT principles, because I have some questions to pose on the VCLT principles, particularly since Ajay mentioned about the MFN decision where 31(3)(b) came into effect. I just wanted to put out three important principles, 31(1), 31(3)(b), and 32, because these three sections, articles rather, of the Vienna Convention have come up for debate in many, many forums. And sir, you have dealt with it in many of your opinions that you have issued in the tribunal. So just for everyone's benefit, I just wanted to summarize quickly what the purport of these three relevant articles are in the VCLT. 31(3) deals with the general rule of interpretation, and the general rule of interpretation which will apply to a tax treaty will apply equally to MLI, because an MLI has to be read alongside the treaty. It simply says that the literal text of the treaties is really the starting point, which is no different than interpretation of statutes in India as well. And it says in determining the meaning, the context of the entire treaty, including its preamble and related provisions, should be considered. And the context here now draws a very important relationship between a double tax treaty and an MLI, because the MLI tends to modify the treaty, but it cannot lose its inextricable link to the treaty, because by modification, it also updates the tax treaty. So there are some very interesting questions that arise on the first rule of interpretation of Vienna Convention of Law of Treaties if you combine it with the MLI. And then, of course, the overarching principles under 31(1) is that the treaty must be interpreted with regard to this overarching objective and purpose. The overarching objective and purpose being the one that is now being thrust by the MLI, which is avoidance of double non-taxation. So now a new principle has evolved under Article 31, yet to be tested. I just wanted a quick view of Mr. Kumar and Ajay on, now that we have this new animal called MLI, do you see any variation? Do you see any change from an Indian law standpoint as to how Article 31(1), the general rule of interpretation, would be viewed?
See, first of all, when you look in the context of the MLI, I think this COP opinion becomes very, very important. And of course, COP opinion is with respect to the MLI interpretation. But then remember, this treaty is an agreement at the end of the day. And if parties to agreement decide some norms on how the agreement is to be interpreted, you cannot say goodbye to that. So, and remember, as far as the VCLT was concerned, it wasn't applicable. It was accepted more by the consensus and the will of all the parties there too. So now MLI objects, and in the light of the principles, the 6 principles they have adopted, these 6 principles may be the MLI specific issues, but yes, to that extent, the principles will be relevant. And as a former judicial officer, I would think that if anyone tries to restrict the maneuvering space or the discretion of the judges in interpretation, that's hardly ever welcome. But if it takes, those inputs take the judge to the same destination where he wants to go, that these inputs are always taken. That's how it really works. So there will be a variation to the extent of taking into account the MLI purpose and the related documents as the primary material, which wasn't the case so far.
So I just wanted to expand for everyone's benefit. Mr. Kumar mentioned to the opinion of the COP. Yes, there is an explanatory statement that was issued, which forms the part of the context of the MLI. This was actually a document agreed to by the parties when the MLI was signed. And the interpretation, it says that the interpretations of the provisions of the MLI shall take into account the text of the explanatory statement, which was adopted by the ad hoc group. At the same time, it adopted the text of the MLI on 24th of November 2016. And it says that it reflects the agreed understanding of the negotiators with respect to the MLI and provides clarification of the approach taken in the MLI and how each provision is intended to affect the tax agreement. So for the purposes of Article 31(2) of the Vienna Convention of Law of Treaties, the explanatory statement forms part of the context for the purposes of interpretation. And this is an important opinion of the Conference of Parties, which Mr. Kumar referred to as COP, approved, which was approved on May 3rd, 2021, which is the date when the initial set of 50-odd jurisdictions came together to sign the MLI. So this is a very important concept that people need to bear in mind for the purposes of interpretation of Article 31(2).
And I think it goes much beyond MLI, because that's the only document available in public domain, at least, which talks about how the parties intended to, interpret the multilateral document or the bilateral documents.
Correct.
And remember, at the end of the day, every treaty has a condition. 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 Every treaty that's the most dominant factor. And every effort of interpretation is essentially an effort to understand that intention, will, purpose of the parties for which the agreement was entered into. And if you have, the parties have also decided how do they want to read this. I think that's an important input for any interpretational exercise by a judicial forum.
Thank you. Just for everyone's benefit, we'll put out this 8-page document for all the participants. Ajay, before I move to 31(3)(b), and I know you have a point on subsequent practice of the parties, which the Supreme Court dealt with in the Nestle case. But anything you want to add to Mr. Kumar on 31(1)?
On this Article 31(1), I think I have 2 points to make. One, if you see in your third bullet under 31(1), ensure fair taxation. Now, this, according to me, is subjective, and that's what the Australian Federal Court has highlighted, that having regard to the changes in technology and the models of doing business, according to them, the enlarged definition of royalty, which is there as part of the domestic tax legislation, is the right approach in order to bring to tax income that is arising from even distribution of software in a particular country. I think this question now of ensure fair taxation, should it be governed by the conventional understanding, or should it be, like we discussed, the ambulatory approach, even without an amendment to the treaty? I think that will be one question that will engage the attention of competent authorities. The second is prevent double taxation, prevent tax avoidance. This, to my mind, again is subjective, and in the context of MLI, when you apply the principal purpose test, there may be a difference in perception between the tax authorities in two jurisdictions, or whether the principal purpose of incorporating in a particular jurisdiction was to merely obtain tax advantage or a concessional tax treatment, or there is substance, or there is justification why a particular entity was incorporated in that particular jurisdiction and not motivated only by tax considerations. I think these are issues that will still arise when you interpret and you merge VCLT with the MLI provision as well. So I don't think there's a conflict to that extent between the two.
Thank you, Ajay. So the subsequent two articles that we wanted to interpret, 31(3)(b) and 32, are not arising out of the MLI.
Right.
Neither are they connected with the dispute that we discussed in the Australian case. But just for the sake of completeness, we felt that by discussing only Article 31, we may not be able to discuss the other two relevant articles which have been subject matter of interpretation in India. One is 31(3)(b), subsequent practice of the parties. The article simply says that in interpretation of treaty, any subsequent practice in the application of treaty that establishes the agreement of the parties, kindly read the word which establishes agreement of the parties. In other words, a subsequent practice followed by both the parties to the treaty would establish an agreement, and that subsequent practice can be used as a secondary tool of interpretation under 31(3)(b) of the Vienna Convention. Personally, I felt that this principle, establishing the agreement of the parties, was completely missed out by the Supreme Court when it rendered the Nestle judgment, because it latched on the Supreme Court in the Nestle judgment erred on two counts. Number one, was there a need to get into Article 31(3)(b) when the words of the treaty were absolutely clear? Did it have to go on to the secondary tool of interpretation on 31(3)(b) was important. Nevertheless, even if it wanted to get into the secondary tool of interpretation under 31(3)(b), did it actually notice that this was a subsequent practice followed by both the treaty partners? In fact, the Supreme Court grossly erred on that count because there was a clear case established here by the taxpayers that Swiss subsidiaries, Dutch subsidiaries, and French subsidiaries of Indian companies who were remitting dividends into India were availing the most favored nation treatment. So now to say that a CBDT circular becomes a subsequent practice was where the Supreme Court grossly erred, in my view. But I just wanted to get a quick view from Ajay and Mr. Kumar as well on the application of subsequent practice of treaties.
I fully agree with what you advocated, Mukesh. That must establish a concurrence and meeting of mind between the two contracting parties of how they want to implement any change in the treaty position through a protocol which incorporates the most favored nation clause, which was clearly missing. Second, I think, as I would see it from a reading of the Supreme Court judgment, what was brought before the court, and we are privy only to what was brought before the court, that does not establish even a subsequent practice across all the amendments that were made in the treaty position. We have isolated instances that were brought to the notice of the court, and I don't think that's a position that covers all amendments across different treaties where this MFN article was introduced through the protocol.
I agree, Ajay. And one more thing which we have to bear in mind is that if you have a practice, so even if it's a subsequent practice, which is in deviation with the agreement, that practice cannot become a determining factor as to what the agreement was. So here is a practice, or here was a practice, which certain countries or the treaty partners were actually involved in, but that practice was in deviation or, which went much beyond the terms of the agreement.
Or it
Now,
may be, sir, it may be in addition. Why deviation? It
yeah,
may be
it
in
may be
addition to the
additional
language of
also.
the treaty. Yes,
So,
only reinforcing the language of the protocol.
You can do anything as a measure of abundant
Right.
caution, but that doesn't alter the agreement. And
Correct.
please also remember, when we look at 31.3, it also says there shall be taken into account together with the context. So if you take it out of the context, and then it says any subsequent practice in application of a treaty which establishes the agreement of the parties regarding its interpretation. Now, if you have a practice which establishes the way it's interpreted, yes, and it has to be one of the factors. It is to be taken into account along with the context. It cannot be taken in isolation. But what has happened in this interpretation of 31.3b is that a subsequent treaty practice, which probably gives some idea about how it's interpreted, and which appears to be going much beyond the terms of the provisions of the treaty, has become the sole factor deciding the scope of interpretation. So it's like you have to use 10 tools, you pick up one tool in isolation and you say this is the truth. We will not go beyond that. That's where the error has occurred in application. There's nothing wrong in 31.3b. I think in principle it's perfect.
All right. We can move the slide to the last important principle on Article 32, the supplementary means of interpretation. This again is not connected with the Oracle case study that we described, but we felt that in the interest of completeness of this seminar, we should debate Article 32. So just for everyone's benefit, this article kicks in where the literal wording of the treaty remains ambiguous or it leads to a result which is unreasonable. Then it says that you can seek recourse to supplementary means of interpretation, and the supplementary means of interpretation would include preparatory works, drafts, negotiations, or the circumstances that lead to conclusion of the treaty. Again, in the context of MLI, the question that arises is that if the terms of the double tax agreement and the MLI are unclear, or if the terms of the MLI are unclear and DTA is clear, which leads to a conflicting interpretation, then can the preparatory work such as negotiation, records of the OECD explanatory statement can be used to understand the intent of the parties. Now, bear in mind that the MLI is a multilateral instrument, and unlike a DTA, where you have records kept by both the countries, here the records are really the OECD, records maintained by OECD, which record the views of the various parties. So in the case of an MLI, this will include OECD commentary and explanatory notes clearly, which offer the context and explanation. And then the subsequent negotiations and interpretations given by treaty partners should also be referenced to clarify any ambiguity. Now you're dealing with multiple variables over here when you have to interpret an MLI, which has to be read with the treaty. I'm sure that the supplementary means of interpretation will evolve as disputes start arising in the context of MLI. But I just thought I will, kind of put this out as a slide and get everybody's view as to how do they see use of supplementary means of interpretation in the context of MLI. Whoever wants to go first.
I think Mr. Pramod Kumar can take this up first. Yeah.
No, when you think of the supplementary means of interpretation, unfortunately, what is referred to as supplementary means of interpretation is being used generally as preliminary or the primary means of interpretation when we see the judicial practices, whichever word we look at. Let's not forget that supplementary means of interpretation, as I pointed out earlier also, there are only three situations when these things come into play. One is to corroborate a conclusion you have already arrived at. Two, when you apply Article 31(1), it takes you to a result which is either incongruous, is something which is patently unreasonable, or there's an obscurity in it. Now, therefore, it's only corroborative thing. You have to reach a conclusion first, and then you have to look whether it's in consonance with this, or if your conclusion is unreasonable, or it looks to be the term they have used in the treaties, is manifestly absurd or unreasonable or ambiguous or obscure. Only then these rules come into play. Now, so far as the MLI material is concerned, as you have mentioned, we have discussed several times during this short discussion, there's already an understanding about how that material is to be used so far as the MLI part is concerned. As far as the OECD commentary and explanatory notes are concerned, then yes, I'm sorry, just 1 second. My apologies. Now, the short point which we must bear in mind is that this should be a secondary material. And anyone who has the task, who has the duty or who has the job of interpreting a treaty provision or MLI provision, he should not use it as a basic material. The difference which has happened in this case is that it is being used as a context. So they have shifted that material so far as the MLI thing is concerned, which in 31(1). To that extent, you can set it in the context for the purpose of 31(1), but going by 32, this comes into only for the corroborative purpose. And I do not see how the explanatory notes and all the material, because what they have covered in the context is virtually all preparatory material so far as the MLI instruments, MLI is concerned. They've taken it to 31(1) as context. So you can't have it in both the places. So the situation, as it seemed to me today, is that the OECD commentary and explanatory notes, the bilateral negotiations and the preparatory work, that gets into Article 32. And what is the MLI document, they get into Article 31. That seems quite unreasonable and absurd to my mind, that you have material belonging to the same class so far as MLI is concerned in one part and the other on the other part. But then that is where the judicial approach, it will be interesting to see how courts view this. How courts also see, whether the courts also see these explanatory statements of the OECD as part of 31(1) for the context, or they, no matter what these committees decide, they view the MLI documents also as a part of 32. That's something to my mind will be is quite fascinating. And I mean, if I was in the job today and this issue was to come up before me, I would have said thank you for intentions, but it will always remain part of 32. No matter what you guys decide, by having your internal conferences that what should be taken in 31 and what should be taken in 32. Inherently, all this material is a supplementary document. It should be part of 32. And if I was to hold a judicial office today and I was to take a call today as to how should I treat this material, maybe I would have discarded those 6 principles which they have set out, except to the extent they are on the same page as a conclusion arrived at on the basis of the judicial principles. So to that extent, from the point of view of judicial approach, I have my reservations to the document. But that's a document which is in existence today. One could also say that you have to treat that in mind even for taking the OECD documents and other material. If this is the intention of the parties and the entire purpose of the interpretation is to find the purpose, the intent of the parties, then so be it.
I do not have a very definitive view on Article 32 in the context of MLI, but I'm just imagining that should a secondary tool of interpretation be resorted to by the taxpayer or by the courts or by the administration, and one has to have recourse to all the preparatory work that led to the MLI, you're really looking at a wealth of material that could come in play. Normally, when countries negotiate bilateral double tax agreements, because of the sovereign nature of the negotiation, very little comes to the notice of the courts, which either the tax administrations could rely on for as a secondary tool of interpretation. However, that may not necessarily be true if you have to rely on the OECD's working documents which led to the formation of the MLI. The simple reason is that the views of most stakeholders were made public, and OECD has been putting out these views in a very transparent manner on the website. Now, all of those views may not, strictly speaking, be secondary tools of interpretation as per Article 32, but those views have translated into OECD coming out with revised drafts. And those revised drafts, in my view, play a very important tool now of secondary interpretation. I have no doubt in my mind that the future of disputes arising out of MLI is very bright. And given the bright nature of that dispute, Article 32 will come into play on high-profile disputes. That's at least the preliminary conclusion I can draw on the relevance of Article 32 insofar as MLI is concerned.
Mukesh, I would want to add, you see, as Pramod Kumar Saab said, the primary rule of interpretation is that you look at the plain language of the treaty. Now you come to external aids to interpretation, and which our courts also use in the context of even construing our statute, is when there is ambiguity in the plain language. Both views are possible. So you can have a view favoring the taxpayer, you can have a view favoring the revenue. And you really need to come to a firm conclusion in which you invoke these supplementary means of interpretation. And I would tend, and we have, in practice, you also refer to the US Treasury explanation, their technical explanation on certain provisions under the US model treaty. Of course, it's a different matter that was a unilateral view that was expressed. But here in this case, the OECD commentary, the basis for coming to a revised draft are, according to me, very material very relevant and material documents to come to a view one way or the other. You are confused, you can't reach a particular view. This will help you reach a balance where one particular view outweighs the other on account of A, interpretation of the language of the treaty, B, the external aid to interpretation that you use in order to outweigh or tilt the scale in favor of one view versus the other. So this, according to me, will necessarily play an important part in interpretation of the MLI or a treaty provision. I had just one comment to make, and maybe you can throw some light on this. The MLI is a broad brush understanding amongst host of countries, but most provisions have generally found their way in almost all of the treaties, except for minor variations. Now, in that situation, the subsequent negotiation that you mentioned in Article 32 and interpretation specific to a particular treaty, we may not have access to that information, but I think it would be the duty of the revenue to bring it to the attention of the court when there is actually an ambiguity in interpretation of the provision of a treaty. I think apart from the MLI, therefore the OECD commentary and the explanatory notes, maybe the documents that ultimately are signed or are exchanged between two treaty partners where the treaty provision slightly deviates from the broad brush MLI approach will also be necessarily have to be taken into consideration.
See, so far as the OECD commentary is concerned, to my mind, it is nothing more than a ready-made analysis, which can be one of the judicial inputs. But the way it has been seen is in a very different manner, where they find it, this is the gospel truth.
No, not that way. I think first you have your own interpretation as on the plain terms of the.
It's as simple as, and then you look at the OECD convention. And the second point I must make is that what I have noticed in my own experiences, that OECD commentary has a tilt for the capital exporting countries. You just can't deny that. I mean, you'll be living in denial if you say, no, there is no tilt at all. And the involvement of the developing countries and the capital importing countries has been more to preempt an uncontrolled reaction to some of the provisions. Even BAPS is seen as that way. So placing too much of emphasis on this is judicially inappropriate. But then it's a constant factor. And another thing I must clarify now is I have an input from Ganesh Rajgopalan. Ganesh points out that according to para 12 of the explanatory statement is not intended to address interpretation of underlying BAPS measures. As a matter of fact, the explanatory statement I've seen only today, but all I can say is that it's something worth reading. Now, what are the nuances to it is not known to me.
Thank you. I entirely agree with you that had the OECD guidance not been tilted towards the capital exporting countries, then a parallel process would not have evolved. In fact, who would have thought that despite developing countries becoming a part of the BEPS inclusive process, there would be a parallel UN process that will evolve, which will be, of course, very interesting to see as we go ahead. This is the last slide. To some extent, we have debated some of these principles. I have quoted some cases that we use it in the context of Vienna Convention, but I just thought I lay down the principle and kind of get everyone's view on this. And again, in the context of MLI. So we now have a DTA and an MLI. The MLI has introduced a variation to the preamble to the treaty for avoidance of double non-taxation, but it still remains, the DTA still remains a document whose primary reason is to align with broader objectives of promoting cross-border trade, investment, international cooperation, and avoiding double taxation. We are not a signatory to Vienna Convention, though our Supreme Court has laid down very clearly that it is an important customary international law. and the principles of interpretation contained in VCLT provides a broad guidance for us. We also have the benefit of Azadi Bachao Andolan, where the Supreme Court made a specific reference to Article 31 of the VCLT. Given where we stand today on the international tax architecture for double tax treaties and MLI, and considering the views that we saw of the Australian court, even though they are interim views, I just wanted to get views from both of you. Do you see this general principle that we have followed, which has stood the test of times, getting somewhat shaken up, modified? Maybe not now, but in the future?
General principle for interpretation, you mean, or the value
Yeah.
system?
Interpretation under VCLT as held by the court, Azadi Bachao. Okay, I have a few questions. We can take them. The first question I'm going to read out, dear distinguished panel members. Given where we stand today in the international tax architecture, I would like to get your views from, one second.
India stance to
Yeah, just
mandatory arbitration.
mandatory arbitration enshrined under the MLI, even though other jurisdictions are giving such a broad interpretation of Article 19.2 of the MLI. This question has been asked by Akshat. Anybody wants to answer it?
I would tend to agree. You see, if you look at the life cycle of a matter which is involved in litigation, today, given the time frame and the areas plaguing the courts, it can take almost 35 years till you have a resolution. So I would think this is a good way to expeditiously resolve a dispute and impart certainty. Mukesh, if you permit me, I just want two comments on the previous slide where Mr. Pramod Kumar mentioned about the changing times. Sir, I would think that a hallmark of a good judicial system and a taxation system is certainty and consistency. So if we are looking at Azadi Bachao being overall today, I would think that the countries are working together to change the treaty position, and there are changes that we've seen in many treaties that have happened. If you look at Tiger Global, it gives you statistics of investments that are coming from different jurisdictions. Now, if you seek to change the goalpost today, basis the fact that much has changed in the international scenario, there is change in business models. It does not. It will throw everything in a limbo. So once countries sit together, they take stock of the position, they make whatever changes they need to make in the treaty provision. And today MLI has come in, which makes substantial changes in treaty position. Until that time, until there is a change in the treaty framework, I would at least not advocate a change in judicial approach or a judicial thinking. The jurisprudence should remain in a manner to impart certainty and consistency to the taxpayer. I think that's very important from a country's perspective as well.
Ajay, I am entirely with you. Consistency is a must, and it never serves the interest of any jurisdiction that they deviate from their stand frequently. But as I said, it's a very subliminal process. It's a process which you become party to this without even your knowing it, in the sense that the value system is changing, and that when value system changes, it is not a change in law. It's not a change in the process. But it is a change on the things which you take for granted. It's a change in the things which you accept. And if we live in denial about this, that's at our own risk. As one of the top lawyers in the country today, you go before the courts more frequently than anyone else in this audience and panel. You tell me how difficult it is today to successfully advance a proposition which would probably be easily accepted 10 years ago.
No, I agree. I agree.
That's what it is. It's becoming a challenge. So
Right.
Now, as a lawyer, you have to defend it, but as an advisor, you have something else to say.
Right. I agree.
So that's what I'm saying, that as a lawyer, it's defensible because there should be consistency. But the value system has changed, and the value system has changed so drastically that I mean, you still have some people who subscribe to those value system, that value system. But once in a while, you see the judgments which touch a different chord altogether.
In a lighter vein, I remarked to a retired judge, or rather, I mustered up courage to pose a question, what's wrong with judges? And he gave me a very nice answer. He said the pendulum has swung the other way around.
Correct. Yes.
So I think that kind of, in my view, is a very philosophical issue. But I just wanted to make one comment on the mandatory arbitration. So I think there is clearly a change that we are experiencing, witnessing, and that change is, in my view, accentuating the risk for business, which also brings to question the competitiveness of any jurisdiction. And I think India would need to be mindful of that. And hence, to the earlier point on arbitration, I don't think that avoiding economic double taxation clearly is the goal. I think as countries jostle for their fair share of taxes, economic double taxation will be a reality. We will have to live with that. So the age-old principle that treaty guides you not to have economic double taxation is now a passé, in my view. Economic double taxation will happen, and hence the responsibility is now thrust on the sovereign to create an enabling environment to seek resolution to those issues. As far as resolution to the issues in the courts are concerned, the jury is out whether walking through this 25-year-old journey, and now, even after walking through 25-year-old journey, a larger bench of the court coming and reversing that decision is clearly a perceived risk by the businesses. And hence, to say that arbitration impinges on a sovereign rights is, in my view, a very, very wrong reading of the Constitution. The reading of the Constitution is very clear. In fact, Article 51 on directive principles says that disputes should be settled in an amicable manner. And I don't think that, that way MAP is also, giving away your sovereign rights. Aren't you surrendering the rights that should ideally be with judicial authorities to an administrative process in a MAP? Subjecting yourself to determination of amount A under the two-pillar solution is also surrender of sovereign rights, because the determination panel will determine the amount A, which gives the allocation of taxing rights to market jurisdiction. So I think we have to get over this wrong perception that has been planted, and serious thought should be given for arbitration, in my view. I don't see how the courts are going to have, with no disrespect to the courts, but I don't see how the courts are going to have the wherewithal to resolve the maze of these issues that are coming up out of treaty interpretation. I'm not hopeful that courts will be an answer to the taxpayers to give them justice on these issues. And arbitration is something that people should give a very serious thought to.
The apprehensions are primarily about the pool of arbitrators and what role India will have in it. And everything stems from that. It is not as much of a constitutional issue as some people may be talking about it informally. The basic apprehension is that if you make it mandatory arbitration and you have the pool of arbitrators which has a leaning towards the capital exporting countries or the values which are not in alignment with our value system, then how much loss can there be to the legitimate interest of the revenue? But that apprehension
that would be an apprehension. I don't think.
I said it in the beginning also. I repeat that. That's an apprehension which is unreasonable. I mean, this is
in a MAP proceeding, you are able to bulldoze and have your view. In an arbitration, you submit to arbitration. You submit to the views of the arbitrator. You are only one of the contesting parties. This is the double tax avoidance agreement is ultimately an agreement. It is akin to a contract. And you take a contract to arbitration, where you are one of the parties who makes a claim or a counter claim, right?
Ajay, I'm entirely with you. That's
Yes.
how it should be
No,
interpreted.
yeah, we are on the same
And
page.
the,
Yeah, we are.
and the judicial system, today there's such a huge gap between the kind of orders we get. There's inconsistency in the judicial results, which is not good, which is not conducive for a good business atmosphere, which is not conducive for ease of business. The Prime Minister is taking pains to ensure that there is ease of doing business. India has a much bigger role to play on the global map, and all of us are overawed by his efforts, by the way the things are evolving. But then in the middle of all this, if you have tax uncertainty beyond a point, then that is to be avoided at all cost. And what is the point of, even if you, let's say, collect a few thousand crores more on taxes, but you miss much bigger opportunities. So you have to balance the national interest and the interest of the exchequer.
Agree.
That needs to be done, no doubt about that. But indiscipline is a big joy, no? Anything that you do when you follow your own instinct and disregard the choice, what ought to be done, it's always, people like to do what they feel like doing. They don't want to fall in line with what is required to be done.
Yeah.
And that happens at the individual level, at the institutional level also at times.
I have an observation on the chat box. Why not make the map process more inclusive in place of arbitration? I entirely agree with this observation, Vijayji. And I think that has also been the endeavor of Action Point 14, because Action Point 14 is just to be able to improve the map process. The map process has been in place for decades. However, it has gone through its own set of challenges. The increase in the map inventory is merely suggestive of an opportunity to improve the map process, which was laid down in Action Point 14. And the two things that stick out really is one, a sense of accountability, which is being thrust upon the signatories to the map process, which is subjecting themselves to peer review. The peer review exercises that are conducted by the OECD are supposed to be a feedback that goes to respective jurisdictions to improve their map processes. What we saw as the August 2020 circular was an example of the peer process feedback. To what extent countries follow that is a matter of debate. To what extent countries have that domestic guidance in adherence to Action Point 14 is another process. Because at the end of the day, soft laws such as OECD or Action Point 14 can do only so much. They cannot be seen as impinging upon the sovereign rights or overtaking the administrative processes and practices of a particular jurisdiction.
But what exactly do you mean by saying, by making map more inclusive? What is that? How can
So
it
I
be?
think the question is that in case a country, for right or wrong reasons, chooses not to go for arbitration, how can you now have elements of arbitration into the map process? I mean, one of the elements was something that was suggested by the UN in Article 25.2, where they came out with a mediation or a conciliation process, just like it happens in an arbitration. I personally don't feel very confident that that a process that could not be settled through the map can be settled through a mediation process, which is one, non-binding in nature. The only advantage I see of a mediation, which is recommended as an alternate in the UN, is the opportunity that a taxpayer gets to participate in a map process, which it does not get, because the map process currently is sovereign function between the two competent authorities. So in a mediation, at least there is an opportunity to the taxpayer.
Right.
All right, we have exceeded our time limit by 4 minutes. I just was mindful of that. Before I hand it over to the organizers, I just thought if there are any last minute comments Ajay, you or Mr. Kumar has?
I think, speaking for myself, we are living in changing times, as Pramod Kumar ji alluded, and we'll have to see how courts now really interpret MLI. There will, according to me, be several disputes that will be landing up in the courts, and we will need to be proactive in order to help sort out these issues at the earliest, in order that there is certainty and there is clear understanding on the side of both the tax administrators as also the taxpayers in the larger interest of the country, in order to attract investment, in order to have a stable tax regime. I think that's what I would want to end on.
Thank you.
I would quite agree with that. We need to be more reasonable, and we need to be more close to what's right on the first principles rather than what's simply in the interest of the taxpayer. As long as we are just and reasonable, and the decision-making process in the judiciary also, I think the contribution that is expected from the stakeholders, particularly lawyers and those who assist these forums, chartered accountants and everyone, there has to be qualitative improvement in that aspect. And in all fairness to the income tax department, if you see how responsive it is today vis-a-vis what it used to be 20 years ago, there's a sea change. And when we talk of the MAP process, the kind of institutional wisdom that sometimes you see in these institutions, some of these officers, they are simply the best. And if there's some reason why they are not able to deliver the result, that is because of the limitations of their role. But not for a minute you would question the
Okay, seem to have lost Mr. Kumar.
Yeah.
Yes, Mr. Mayur Naik, would you like to take over from here?
Yeah. Thank you very
to
much.
the- yeah, thank you. Thank you.
Thank you.
No, Mr. Kumar, please complete. You were just making a last comment. We missed you for 30 seconds.
No, it's okay. That's what they were saying. It was all general terms. There was nothing much. Please carry on.
Thank you, esteemed panel. Friends, you will all agree that it was one of the very enlightening session we had in the entire course, and the underlying message by the panelists that change is the only constant thing. And as we are experiencing in our judicial pronouncement in the international tax fora, and the way things are developing worldwide, MLI, and now pillar 1, pillar 2, again we are going to have a lot of changes, the way tax would be distributed amongst the nations, and the way the tax administration is going to go forward. Friends, with these few comments, and I would like to thank the ST panel once more and hand over to Kush to propose a very well deserved word of thanks. I take this opportunity to thank all the speakers who have made this course successful, all the participants, and special thanks to Prerna and Kush for taking this course forward, designing it and making it possible. Over to you, Kush.
No, thank you, sir. I think the only way I can describe this session is that it was akin to an exhibition tennis match between Nadal, Federer, and Djokovic playing together. So very enriching for all the participants, I'm sure, and a lot of very important pressing issues were discussed. So thank you to Pramod sir, Ajay sir, and Mukesh sir for kindly sharing with us and taking the time to put this together, and special thanks to Mukesh sir's team for the last minute preparation and putting this session together. So on behalf of IFA India, WRC, and all the participants, thanking all the panelists and appreciating their efforts. Thank you so much.
Thank you. All the
Thank
best.
you. Thank you. Thank you. Thanks a lot.